Oh, I apologize.
February 6th.
Well,
And we are going to look at and possibly vote
siblings room.
44. And over to you, Ben, to
Thank you, Mr. Chair. Bear with me one moment as I pull it up on the screen for your viewing pleasure. So for the record, my name is Ben Novogratski from the Office of Legislative Counsel. Before the committee are two versions of the bill. Draft 1.2 is an unedited but highlighted version of highlighting the changes from the last version that the committee viewed and this one. And then draft 2.1 is an edited, clean version. So if you're prepared to vote, that's the version that you would be voting upon.
okay, so we have version 1.2 is the same exact thing as version 2.1?
Yes.
Without.
And maybe some minor spelling and grammatical errors since it wasn't edited when I sent it.
All right. All right.
So
What am I looking at?
you're looking at version 1.2 right now.
Bless you.
Thank you. So the first change is relatively small on page 2, line 5, which is the addition of or adjudication. So that line now reads, the family division shall forward a record of any conviction or adjudication for a violation of a law related to motor vehicle traffic control, other than a parking violation, to the Commissioner of Motor Vehicles, to cover the family court dispositions, if you will, since they're not convictions per se. Then finally, just affix to the cross-reference on line 15 of page 3 to specifically cite to the serious bodily injury definition. Then you'll see on the next page on lines 15 through 18 that we've completely struck that refusal to comply with the search warrant language because the revision to that language has been moved farther down. And you will see that portion, and I'll get to that in a second. You'll see on page 5, line 5, the addition of or J, and that was from the discussion yesterday about ensuring that someone can't be charged for both a refusal and a DUI at the same time. And so you'll see that in J why that is the case. And then there's now a new version of subsection J, which reads that a person suspected of violating this section shall not, rather than hinder, refuse to submit to the collection of an evidentiary blood sample when a warrant for the person's blood is issued pursuant to subdivision F1 of the title, which is the warrant requirement for blood draws. And then again, that the subsection is not construed to impair the person's right to challenge the validity of the search warrant itself. Representative Oliver.
You're saying they cannot refuse.
I mean, they shall not, but if they do refuse, then they can be charged for refusal.
Automatic.
Yeah, because that was present in the last version of the bill, and this is just to clarify hinder versus refusal.
Okay. Yep. I'm with you.
And then going farther down, and this is again that subdivision C of 1202 that refuses not to comply with the search warrant, since we had that discussion about, well, it's really an obligation on the law enforcement officers, not so much on the individual subject to the warrant. But this goes to their refusal of the collection of the blood sample. And so this would now create a basis to charge them with a criminal refusal. But you'd have to choose one or the other.
Good comment. What do you mean more or less?
I guess.
Yeah.
Sure.
I don't entirely, yeah, I do.
You're not making me feel good.
Sorry.
Well, you're the, so may I?
Yeah.
You're the law enforcement.
He's not really here testifying, but I do want him to be comfortable with what we're doing. If we're not, what do you need to, do we need to change it somehow?
Well, you're being brought in for the DUI. You're refusing the test. And they get the warrant, or just because it's a fatal,
No, it's not for fatal, so this would be you'd have to get the warrant to obtain the blood
refusal.
sample.
they're refusing, so I get a warrant and then they refuse.
Mhm.
But through implied consent, says you've already agreed. So it seems to me that if you break that contract, it should, are you following?
I do follow. It's a little bit different with the blood test though, because a blood test is more intrusive.
Right, I know it's a little
Yeah.
bit more intrusive. I'm sorry if that stinks, but you could blow on the machine too.
And this gets to subdivision 2 of 1202, which is the reference on page 6. So if the breath testing equipment's not reasonably available, so really it's that's
So it's our fault.
you,
No,
one could
I'm
phrase
okay
it that way. Then, but there's still, or they're not able to give the breath
Because they
test
have an injury
for whatever reason. Or if they're under the influence of a drug other than alcohol, person is deemed to give a consent for taking that evidentiary blood sample. But you still have to seek the blood test pursuant to subsection F, which requires if a blood test is sought, this is again, and infuses the blood, the evidentiary test, and you apply for a search warrant.
So I wouldn't be applying for, well, I bring you in, I offer you the blood sample or offer you a breath test, you refuse. I have the equipment there, you refuse. I could charge you refusal or I could go for it.
Well, it would have to meet one of those preconditions.
So I had the equipment. Well, then I could just go straight with the refusal there.
I defer to the practitioners on that one.
That's what.
Yeah, go ahead.
Who, you defer to who?
To Marshall and to Attorney Paul and Attorney Wigmans on what they would do in that situation.
Okay, one more.
Go ahead. Yeah.
So, Tom, not to put you on the spot, but I really wanted to hear what you had to say. So I apologize for that.
No, it's fine.
I really needed
No,
knowledge.
no, I got it. Yeah,
Okay.
it might have helped me too.
All right, proceed.
Okay,
I'm
so
still confused.
Easy with this, Bill.
God.
okay, so picking up where I left off, I think.
So now you're confused.
Well, I'm confused on where we left off.
I think you were moving up from page 6, weren't you?
Was I on page 6?
Yeah, well, you went from 6 to 9 probably.
Yeah, I'm on page 9.
Okay, page 9, so that's for the last place, so then the next highlights are very far down towards the end of the bill on page 20, which is the beginning, which is section 3. And this is regarding the discussion that was had yesterday about the order that needs to be sent, and whether or not it's a merits adjudication, a delinquency, and through that discussion, it was determined that, I suggested a disposition order, but you don't really get to that point necessarily. So the merits adjudication order, issued pursuant to subdivision 5229 of the title, concerning a child or youthful offender who is alleged to have committed a violation of those sections in 801A1, shall be an event in addition to those specified, enabling the commissioner of motor vehicles to require proof of financial responsibility. So that's the threshold, is that merits adjudication order rather than the delinquency order, which how previously was.
Okay.
No other changes to this part, and then the merits adjudication. So this is the cross reference of that of what I just mentioned. And changing from, rather than shall send a record of such findings to the Commissioner of Motor Vehicles in accordance with those other cross-reference sections, it's just sending a record of the adjudication to the Commissioner of Motor Vehicles within 10 days.
So you decided not to put in the, what 23 VSA 1709 requires? That wasn't necessary?
That's the 10 days, essentially. It's my summation of that and of 33B.
Okay. All right, thanks. All right.
Okay. And then again, we just added the chief judge of the Superior Court or designee to the impaired driving processing task force. That is the final change.
All right. Any questions for Ben? So if you can unshare, and then we'll go to Dennis and then to Marshall. So where are we with this from your perspective, Mr. Wigmans?
Good afternoon, Dennis Wigmans, State's Attorneys and Sheriff's Department. I think that we're there. I heard some confusion about how this plays out. And I thought it might be helpful for me to kind of put this into context of how a processing usually goes. And when it seemed to be some confusion about when we can charge this new refusal proposal. If an officer, sure.
Before you go ahead, just Tom, did you?
It's clear with me. If you want to go on, that's fine. I just wasn't aware of where we were in the processing, I guess, when that came up. That
Sure.
point. Good.
So, yeah, to pinpoint it, where we are in the processing here is you are in a circumstance where you either A, right, the equipment's not available, or B, it's a DUI drug case, right? And so we're going to get blood. A warrant has been issued by a judge. You can't get a warrant on a DUI 1, for example, if a person refuses at that point for just a ethanol case, if the DMT is available. So this is no DMT available or a drug case. You have a warrant and the person refuses.
All right. Any other issues or comments with regard to the rest of it?
I mean, I think I'll defer to Marshall. I was looking at the subsection 3 under 5202 and wondering if that's where he was also talking about putting in that same reference to 5229.
Okay, all right.
Because it still has the same language of establishing youthful offender status as opposed to adjudication.
Right, okay. All right, so let's get Marshall up at the witness seat then. So we're gonna kick Ben out and so why don't we start with Marshall, if you could get yourself right.
Logbook here, right here.
It's not, but I've been looking at it and wondering if I can
Where
deal it because my office copied a 2024.
Yeah.
But I don't have a 2025
Michelle,
yet.
sorry, you can't take your, so.
Michelle's.
Yeah, sure.
Right down here.
Sorry.
I was looking very enviously at it yesterday when I was sitting there with my miscolored family logbook. So Marshall Paul from the Office of the Attorney General. And to pick up right on the issue that's on page 20, I would agree with Attorney Wigmans that there's still an issue around the language or establishing youthful offender status in proceedings concerning a child as youthful offender. And the reason is that establishing youthful offender status is not establishing any sort of adjudication that you've done anything wrong. It's just establishing that you get to be in youthful offender court. It's really the adjudication where you actually have a little trial, a bench trial, and I shouldn't call it a little trial, it's a serious trial. It's just not in front of a jury, it's in front of a judge. And you put on evidence about the alleged drunk driving incident, and the judge says, yes, I'm going to find that you are guilty of, that's the point that we need reported Not that somebody's been granted youthful offender status, that wouldn't have anything to do with their DMV status.
So what would be the appropriate language there?
If we needed the language there, it would be, notwithstanding subsection 1 of this section, an order of delinquency. What I would put is an order of adjudication issued pursuant to subdivision 5229 of this title, just like is in the section above it, because that captures both delinquency and youthful offender, because they both refer to the same statute on merits adjudications.
So wait, page 20, line 12, is this?
Page 20, I'm looking at line 18, 19, 20.
Wait, oh, you're not looking at, so
That's the good language.
the language is fine on line 12
Yes.
and 12, 13.
It's 18, 19, 20, where there's the language that says, or establishing youthful offender status.
Oh, okay. So you want an order of adjudication.
Wait, it could just be an order where you could replace the entire, an order of delinquency or establishing youthful offender status with a merits adjudication order issued to pursuant to subdivision 5229 of this title.
Or just that same language.
Yeah.
Right. Do you need the concerning? Oh, in proceedings concern, okay, all right, got it. Okay,
I think other than that, we have no concerns. Other than that, this is just what we discussed.
okay. All right, so we'll have that change and we'll put it up to a vote tomorrow. Either right after the floor or right after lunch, one or the other. So I think we have 10 minutes and maybe we can get to H41. Or at least we can hear about it. And if we just, since we have 10 minutes and we can,
The change has been made to 44.
okay. All right, over to you, Ben.
Highlighted version.
Highlighted version, yeah.
Highlighted version's a little clunky to read, just FYI. But it's a way to see the differences, I suppose.
Thank you.
All right, so these are all the differences
From the prior version or
from the prior version. I thought that weren't that significant. All right, go ahead. All right. No, I just thought that really, since the last one we looked at, the only real changes were getting, well, I guess I see some other ones that you're getting.
Yeah.
All right, go ahead.
Okay, so I'll pull that, the
Yeah, you're good.
highlighted version up then. Green. Okay, so you'll see a lot of changes from the initial amendment. Some of them are sort of technical to be more fitting within Title 13. For instance, rather than using individual, it's now no person. But also we're essentially changing the layout of the statute as well. Because previously, hides, desecrates, or otherwise concealed was a felonized action in title or in subsection A, which carried the 5-year penalty. Since those actions are arguably covered by 18 VSA 5211, we're going to remove them from subsection A, and they're being added to subsection B with that additional element of with the intent to conceal a crime, apprehension, or conviction thereof. So what that does in effect is that you need to have that specific objective that you're hiding, concealing, or otherwise concealing a body for that specific purpose of avoiding apprehension, or other consequences of that crime. So that's a big substantive difference, because before you could have been, charged with a felony just to move the body. And there may be some situations where it's not, and again, this is a policy decision, but there may be some situations where you may not want to subject someone who just moves a body. Maybe they're, don't have the financial means to do something properly. And so what would happen then is that rather than being subjected to this 5-year felony, they could just be charged under 5211, which as you'll see later in the bill, strikes the imprisonment penalty and just makes it a fine.
Yeah.
So that's the big impact there, if there are any questions.
So I think this language is a little clunky, actually, since we looked at it last. And it's still not clear what the knowingly goes to. And I think having the language along the lines that,
I would look at the clean version.
well, no person shall knowingly without legal authorization intentionally burn, mutilate, and dismember, right?
Mhm.
But I think it should be, that the person knowing that they are not legally authorized. 'Cause I don't think it quite has the same meaning, or does it? It should be that they know that they don't have legal authorization and they proceed to burn, mutilate, disfigure, dismember. And I don't think it's as clear the way it is here. Ian?
So yeah, I think we were trying to get at this issue that we didn't want someone to be subject to this felony level if they didn't know that they didn't have the conviction, right? That was, I think, where we were before with the drafting. So if you got rid of the first,
I would say it still fits that bill, but it can always be clearer.
what if you got rid of the first comma?
Well, again, this is why I encourage you to look at the clean version, because this one is also not edited. So that's why I would advise switching. You can keep the paper copy, look at that, but let's look at the clean version that's edited.
Version up. We'll put the clean version up. That's fine. Yeah.
But can I ask a question about this?
Yeah.
So is it only the fact that we're only trying to get to the fact that someone knew they didn't have legal authorization
And
they knowingly did these things, right? Isn't the mens rea applying to the doing of the thing as well? Originally, I
We have
think that's
intentionally as well.
in a different,
Same line. So knowingly.
oh, I
So,
see,
yeah,
I see.
so, yeah, so-
Right.
So yeah, you're right. So if you knew you didn't have legal authorization, but you accidentally burned the body, that would not
Right.
fall within.
Yeah, no. Ben, why didn't you tell us to look at the clean version?
Yeah, you could let us know.
I think I did 4 times.
I mean, the language isn't different. It just might be clear to read.
Can I ask a question?
Yes, please.
What stopping somebody from entering a insanity plea on this and escaping this? Well, I mean, anybody that goes to this extent to do this to
That's a whole other.
Yeah, that's a whole other process about competency.
Insanity, not guilty by reasons of insanity.
well, you'd almost have to be that way to do this.
I can't speak to that.
That's speculation.
I think
So-
the testimony sort of
The
saying,
defendant now has to prove it themselves, if I remember right. It used to be the state that had to prove it.
Yeah.
So that's a whole different,
That's a whole different kettle of
that's a whole
fish.
different process to go through.
But we basically got that covered.
Well, we can do it with any crime, you can do that, I'm sure.
I still think it
That's true.
reads
Okay.
better if it's no person knowing they are without legal authorization intentionally burns, mutilates, etc.
I think he gets to it in this way, but I will happily make the change.
Can you very briefly make the argument for why it works that way? Because I kind of agree it doesn't.
So if you take out without legal authorization, you have 2 modifying
Yeah.
Yeah, that's a good point.
Oh, that is.
of mens rea. So, because normally when you just have one, the conventional legal principle is that it carries throughout the whole subsection or statute. This knowingly before legal authorization, then intentionally following it indicates the different level of mens rea for each portion.
That makes a lot of sense.
Knew you intended to involve the body.
I still think it's awkward.
So can you say your suggestion again?
I mean, especially with the comma, maybe if you took the first comma out. I know, well, no.
That's what I was thinking.
But I know that they like commas before, the phrase. And,
It's a different thought.
No person shall knowingly without.
We're looking at the underlying bill and letting editors.
no, I still think, really think no person shall, knowing they are without legal authorization, shall intentionally burn. I really. So.
The table's head's ready to explode, I know that.
Oh, no, we need some comments.
Yeah.
So Marshall Paul, I'm gonna ask
We
you.
take 'em all out.
What you would, in practitioner, prefer to know what you're.
I would certainly prefer the language you proposed, and the reason why is that there is a canon of statutory construction that is not always followed, but is sometimes followed, and that makes it really frustrating for us as practitioners, called the last reasonable referent canon, which means that any modifying words refer to whatever the last reasonable thing they could have referred to is. And that is a complicated doctrine to implement, and it often is very subjective. And that's why I like it when we like if knowingly is meant to apply to without legal authorization, it says knowing that they do not have legal authorization, because then it's clear exactly what knowing modifies and what it doesn't.
I would just say that 3 attorneys looked at this in my office.
Fair enough, but we're just trying to talk to common man. So what's that thing called? Last what?
The last reasonable referent canon.
Wow.
Oh, I love it.
That's mouthful.
All right.
It gets it's in Scalia's book on interpreting statutes,
Oh, well,
which is a
I would humbly suggest that even if you were to fully understand that principle, it may not help you lead to the answer here.
And I think that's true, which is why I suggest something that specifically says, knowing you don't have legal authorization, because that's been our experience, is that canon is very imperfectly applied because it is such a vague and subjective. I mean, the whole point of canons of statutory interpretation is that they're supposed to be non-subjective and very easily applied, and that one in particular is just not.
So I really think it's.
I want to know what's going through Ian's head right now.
What am I doing here? I love it too.
So we can take this over, but no person knowing they are without legal authorization shall intentionally burn, mutilate, disfigure, or dismember. I really just think that is clear.
Well,
Nothing by the bell.
no
Yeah,
person
yeah.
shall knowingly that they, right?
If the
You
no
can't say
person,
You
comma,
can't say they.
okay, so it'd be no person shall.
Really? We're not doing that? I thought we were.
Person.
We just use the person rather than he or she.
But what if it's a different person?
Say they. Huh. So no person shall-
I thought that we could use they.
Oh, yeah.
On our drafting convention.
When did we not do that?
We're
Okay,
replacing all the
so-
gender language
so-
with like.
That's not
That's not so, okay, you're making your point, I see. With actually putting that, well, I think it's clunky as hell, but if you say that it works,
Your 3-person team reviewed it.
Myself, Attorney Childs, and Attorney McLean.
yeah.
So I would advocate for both of the commas to come back in that case. No person shall, comma, knowingly without legal authorization.
Oh, you want the comma after
You
shall.
move the comma.
Oh, yeah, I like that. No person.
shall, comma,
comma,
knowingly without legal authorization.
Nice, comma, that works for me.
Intentionally burn.
But now, beautiful. I love commas. Commas are beautiful things.
So you
So-
could vote on this, but it would be 3.2.
No, we're gonna vote on it tomorrow sometime. So.
That's gonna.